Okay, let's get started for today. And this is our final session. We're gonna cover real estate related to business law. And the reason why we like to cover real estate, probably there are multiple functions. For your business, as I mentioned, sooner or later, it's better off sooner, okay, than later. You may consider to rent your office. You may consider to rent. You're gonna expand your business from your home business to a regular, much more regular and normal type business. So you can invite your client, your customer to your business location, right? So the reason why we mentioned the real estate law related to business, and I think bottom line is to meet your basic business expansion plan, all right? And other than that, probably your business may consider to invest your cash to the real estate market, all right? So it doesn't matter what kind of business you are in, you may always consider to spend your cash on hand, cash in your hand. And everybody reading the news, how much cash? We are not mentioning Apple. Apple is the largest one business in the whole world. How about Samsung? You read the news, how much cash? Eventually for this kind of business, they are not, eventually for any kind of business, you are not supposed to hold too much cash in your hand, right? In order to run your business, you should keep less cash, I should say keep minimum cash in your hand. We're gonna talk about the cash flow or cash management for my advertisement for next semester. When we talk about financial accounting, I will tell you why. I will tell you why, because this whole lesson. I will tell you why, as a business owner, you are expected by your shareholder to keep as minimum cash in your hand. The reason why? Because the cash is the most important business resource. You should invest your cash on your business. Say for example, you invest your cash on inventory because that is inventory gonna bring in your more profitable transaction, right? If you just hold your cash in the bank, at the best 1%, at worst nothing, and even worse if you have a risk, okay? And so cash is the bottom line is, don't hold too much cash. However, sometimes you just cannot prevent that. And if you read the newspaper from last week, Samsung, they are holding $400 billion cash. $400 billion cash. You are not talking about the assets, you are talking about cash. So, well, doesn't matter what kind of business line you are in, somehow in the future you may consider to invest certain amount or certain percentage cash into the real estate market as an investment. All right. So I think this is one reason we need to talk about real estate law, even though probably this is not the main project or the main business line for your business, but at least consider this. We have a few very interesting cases we're going to talk about. When you get into the lease agreement, I think certain item you need to be very, very careful. Let me just give you one idea. A few of my clients came to see me, and the very common problem for their business. Oh, by the way, your name? Tyson. Yeah, Maria, I already checked. So much. Yeah, there's one very common type problem for their business. To start their business, they sign out, say for example, 5 years lease agreement, 5 years lease agreement with the landlord. However, down the road, say 2 years, 3 years after, they feel business is not going very well. They would like to renegotiate with the landlord. And you know, very good chance the landlord play very tough. We say we will not renegotiate, and this is the lease agreement. So eventually, those business owners, they are stuck. Because they are bound by the lease agreement. Say for example, they pay 5,000 every month just for the lease. So every year there's 60,000. If there are another 2 years, 3 years left, it is their liability. So you know, this is one example. Another example is also very common. Probably you heard about that. For those small business like retail, donut shop, for example, okay, dry clean shop, and they are running very small scale business, but once in a while they receive the letter from the person they never known and claim is ADA damages. Everybody heard about ADA, American Disability Act, and to claim you are running your retail store, however, your facility does not provide the ramp, handicap, wheelchair ramp, no such facility to provide, then they got the claim, and they just come to see me. I say, this is a very typical, either fraud, you can say this is a fraud, but somehow, you know, it is trouble for the business owner. And that is also another very common practice. If you are running your business, small business, you may hear about it. You may. It's not strange. Okay, it's not strange. So I just give you a few examples to tell you why. Doesn't matter what kind of business you are in, you may at least know a little bit about the business, real estate law, a little bit about that. All right. So on the screen, this is our outline. Okay, we will have probably 4 topics to talk about that, but I may focus on the number 1 and number 3. Right? We talk about number 1. What is the real estate? What is a real property? What's the difference between real property different from personal property? All right. And however, I have a caveat. Okay, Okay. I need to give you one announcement. The real estate law is different throughout 50 states. Okay, the real estate law is not federal law. Okay, even though federal may pass, the federal law to regulate. However, the major difference between real estate, real property, different from the personal property. If you still remember, when we talk about personal property, which law we covered? That is about 2 months ago. I'll be surprised if you still remember that. You remember that when we talk about the goods, transaction, I believe these are the number 2 or number 3 lecture for this semester. There is one federal law govern the goods, the personal property sales transaction, and I remember I gave you the homework eventually. Your number 2 homework. What kind of law? What's the name of the statute? Still remember? If I told you, everybody say, "Oh, I remember."
Was it demands vote on gun control?
No, this is the first one. How about second one? Close. I gave you the second homework.
Second Amendment of the United States?
No, this is still the first one. What's your second homework? You turn in. Yeah. UCC. Uniform Commercial Code. That is a federal law. Eventually, I should say, take it back. It is federal passed, however, recognized by each state. So it's called uniform. So for goods, for personal property, for goods transaction, right now is almost all unified already. Unified means throughout 50 states, almost the same. The same regulation, the same law govern personal property. However, that is totally different regarding to real property. So each state is different. So that's why I cannot teach from the book, because this book is universal. So just be careful, okay? When we talk about the real estate law, we need to specify which state. And for this class purposes, I will focus, of course, you know, I'm a California lawyer. I can only focus for California, all right? So when I say law or definition, basically I'm talking about definition under California law, all right? So we're gonna talk about what's the real estate or real property. Then I will tell you why is the difference to do this kind of differentiation. Okay, there are 4 type real estate. 4, they are in your book, okay? The first one is land. When we talk about the land, no problem. It is real property, all right? Second, we talk about anything building on the land. Say, for example, building, bridge, tower, anything built on the land. Okay? Man-built or natural. Natural means natural growing, tree, vegetation. Okay, before we harvest, cut it down, it's part of the land. They are defined as real property. Okay? Number three is more abstract. It's something defined by the law. Say something we cannot see it. However, it is defined under the law. For example, the right of the way. For example, it's called easement. Okay, easement. Say for example, there are 2 parcels. There are 2 parcels of the land, and parcel A, for some reason, block parcel B. Okay. Say there are 2 parcels, 2 pieces of the land. Say for example, this is the road here. And it was 1 piece before. Originally, it was 1 piece before. But at some point of time, the original owner just divided to 2 pieces, to 2 parcels, legally, okay? So right now, it comes out like this. Parcel A, parcel B. If parcel B is totally blocked by parcel A, then we need to figure out something for B to access to the road. So we can design one passage. Okay. This passage, this road, private road, legally still belong to parcel A. Legally speaking, the title still under the belong to parcel A. However, this area provides the access to the owner of parcel B, and we say this is we call this easement. Mean this is the right of access, right of way, and easement is one type of real property. So sometimes people got confused, okay? Easement belong to the owner of parcel B, even though this area, the title is under the owner of parcel A, understood? So for this portion, there are 2 types of real estate. The first type is called land, right? Land belong to the owner of parcel A. However, the right of the way is called easement, belong to parcel B. So it sounds very strange. However, for the practice purposes, county, okay, may collect twice real property tax. Hold on 1 second, okay? So for the practice, okay, because this area, there are two types of real estate. The first one is regular land, right? So county will charge one time the whole area property tax, collect property tax from the owner of parcel A. In the meantime, this portion, even though it's not located in the B area, however, this is another type real property called easement. So when the owner of parcel B every year receive the real estate bill from county, it will show the regular property tax for this parcel B area, and also plus one value, we don't know how much, one value on this little easement area. So that's for the practice purposes. So this is why I need to differentiate why easement is under the definition in California or most of the state, it is another type. I will answer your questions. The number 4, okay, definition of real property, everything immovable, everything you cannot move, like a rock. The rock, if the rock is large enough and then we cannot move it, it becomes a real property. The thing is, sometimes it's very difficult to differentiate whether or not it's a rock or it becomes island. When I say rock, not really the rock on the land. I'm talking about the rock along the beach, right? If you go to hiking, you know, along the highway 1, you see a lot of rocks. If it's too small, it's no value. But when the rock large enough, then it may become an island, right? So everything immovable becomes real property. So go back to Maria.
I was wondering if you're actually talking about a real case that's going on right now?
Yes, it's a real case. The reason why I want to mention this idea, this concept of easement to you is because if you, in the future, you sought any property tax bill, okay, or any friend of you ask you, how come, you know, on my property tax bill I see the easement value? What happened? So, for example, the owner of parcel B, he or she just purchased this parcel recently, and the first time when the new owner received the property tax, and he or she will see two portions. One portion is the value on the parcel B. That's very understandable, no problem. However, if on his or her property tax bill see, wow, the value of easement, what the heck of this? And that's this portion. So I just want to let you know what's the concept of easement. Easement is the area under somebody else's land, but you, as the owner of the neighbor, you have such right to get past. And this owner of parcel A cannot block the access. And also the easement doesn't matter how long you have not exercised. You can always there. Easement is forever, unless you have a mutual agreement to terminate it. So at least, you know, I want to begin with this class and give you the idea what is called easement.
I actually got a complaint filed with our office, and I wrote a synopsis about that complaint. And I'm not going to mention any individual who filed that complaint. It's just interesting how what you talked about matches with what I got.
Mm-hmm.
The easement, because really, there's one person actually buying these, you know, for that purpose of getting business.
Okay, all right. Right, so probably we will not get too much detail about the easement. However, at least after this class, you heard about easement and you know what easement is. It's one type of real property.
Does the owner A have to be allowed the easement goes through on their land?
Yeah. Oh, by the way, let me repeat Pepe's questions. Does the owner of parcel A must allow the easement, I would say, created, right? No, of course not. think about this. Imagine, okay? Let's go back. A few years back, okay? Remember I said, before the easement created, it was the whole area as one parcel. Few years back, okay? So eventually there was no any easement before, okay? So few years back, and the whole parcel is only under one owner, so there's no easement. And for some reason, and also go through the legal process, the original owner applied either to the county or to the state to get we call subdivision. That is belong to the number 2. If you look at, we will not spend too much time on the number 2 topic for today. You see, environmental law and the land use control, and that is for the builder. For all of the builder, they are focused on the number 2. All right, they deal with the environmental and deal with the permission to develop from the raw land, the vacant land, and then they get the permission, they get the plan approved either by the state or by the local government. Then they subdivide it. So subdivide means you can legally divide this whole big area into the small lot. Then you can build each either single house or condominium, cut it to the smaller lot, so you can build more property on it. So let me go back to previous questions. So how was the easement created? All right, so that's called subdivision. I just simplified the whole scenario, okay? So it was a one-piece land. If the owner did not apply for subdivision, it will keep the way it is forever. Remember I told you the story a few months ago. I helped one of my clients, is a very old gentleman, 90 years old. So healthy, okay, 90 years old, and still can hunt it, do hunting every year. And he came to see me with his wife. Came to see me. He said, "I have one piece of the land I want to transfer to my 2 boys, and I want to save any transfer gift tax, and also try to avoid the property tax." We'll talk about that a little bit. I will try to avoid the property tax being reassessed. And I look at their tax bill. Right now, every year they only pay $800 for the whole pieces of the land. And when I look into the detail, you cannot imagine how large the land it is. Okay, the land is more than 600 acres. You know how large 1 acre is? It's more than 42,000 square feet. And you know how large your family, single family lot usually is 6,000. If you're living in a single family home, usually, averagely, your lot is 6,000. So 1 acre is almost like a 7 single family home. And I'm talking about 600 acres lot. And this gentleman only pay few $100 every year for property tax. And no surprise, because this is one generation to generation inheritance from the generation. So this gentleman just come to see me. I want to transfer to my boys. I want to avoid the gift tax. I want to save property tax. I want to keep property tax the way it is. I said okay. So I done that for this gentleman. So for example, if this piece of land is 600 acres, if you don't do any subdivision, still one piece. You can only at best build 1 house on it, right? And then if you want to transfer, you want to sell to anybody else, you can only sell the whole lot. You cannot just cut a corner. You cannot cut a corner. Hey, I sold you this corner. I sell 1 acre. No way, because this 600 acre altogether is 1 unit, considered as 1 unit. So does not make too much sense, right? If you want to sell this property, it's all or nothing. In order to subdivide it, you need to go through the whole procedure. Then after you get approval from the state government or the local government, probably you can cut it to like 600 pieces. Then you can individually sell to different buyers. So that is the whole purpose of subdivision. So go back to Pepe's questions. For some reason, this gentleman just cut to the half. Just cut to the half. And I don't know, for any special reason, this gentleman did not cut like this. If cut like this, no problem. Each lot you have access to the road. But I don't know, for any reason why, very strange. And this gentleman just cut horizontally. Okay. If cut like this, then it becomes a problem because the lot behind it is the block, right? It's locked, right? So for this, any type of this kind of arrangement, you need to consider the easement. So this is how the easement created. So to answer Pepe's questions, no, you don't have to. If you are the parcel A, you don't have to allow the easement for parcel B. But think about this. If you are the owner of both lots, right? Still under your title, then there's no problem. But somehow, someday, you are considered to sell one parcel, right? To get cash, right? So, for example, you are the original owner, and right now you are considered to sell lot B to somebody else. At this moment, if you're so stubborn, say, I just don't want to create any easement, then nobody gonna buy it. Is that right? So, yes, legally speaking, you don't have to create. But however, if you don't create it, there is no economic value on it. Without easement, maybe lack of any economical value. And how about the other example? You want to keep this lot and sell the front lot. Of course, when you sell the front lot, you will reserve the right for the access, right? So this is the reason why for necessity, any reason of a necessity. So this is one of the reasons easement are being created. So at least, you know, I just want to give you the idea in the future when you consider to purchase or invest in real estate. Then when you read the idea of easement, don't be surprised. Just be careful which side you are. Or by the way, if there were easement, usually the cost for maintenance usually is shared by both neighbors, usually. And you will see there is this agreement. Very often time you can check the agreement is recorded. It's recorded at the county. All right? And then next issue is, yes, go ahead.
Oh, I just thought this kind of like private, if it's like a condominium, like
yes.
They have park
Yeah.
area.
Yes. Eventually, I will hold out this issue later on for condominium because I will talk about so many types of real estate. Okay. I'm only talk about the definition at this moment. I will talk about what's the difference between single family and the townhouse and the condominium and timeshare. I will reserve. So if I forgot it, remind me. Okay. Eventually, for the condominium, we don't use easement. We don't use this easement idea. We use a common area. Common area is different from easement. Easement really means you use somebody else's property as access. However, you know, you all understand for condominium, you don't use somebody else's property. You use common area. That means, you know, for the whole community, for each owner of the unit, you own the street. So it's a different idea, but let's go to that point later on. All right. And how many of you still remember? Eventually, I mentioned this already. And why do we care about the difference between real property and and personal property. Eventually, I mentioned this when we talk about UCC. I just want to give you a test. How many of you still remember when we talk about the sales, when we talk about transfer the ownership, and we see the first difference. So everybody still remember, I talk about this. When we transfer the ownership of the personal property of the goods, what kind of legal document we use to prove the title transfer?
Bill of sale.
Everybody heard it? Right.
Bill of sale.
Yeah. Bill of sale, or say receipt. Okay, receipt. So this is more like a review. Okay, we see why do we really care about real property and personal property? Yes, we do, because if the item is personal property, we use bill of sale to transfer the title. And how about real property? Yes. So good. You got an A, huh? All right. So I have real property, personal property. So when we transfer title, we use D. And here we use the bill. So this is the first big major difference. So when you transfer, say, camera or computer or projector, when you sell this item through, say, Craigslist, and you are the seller and people come in, pay you cash, and usually you sign on the bill of sale. Usually, okay? It's a one piece of paper, the title says bill of sale, and you are the seller, and you fill in the name of the buyer and how much they pay. Usually, you want to collect cash. For those people come from Craigslist, you better off collect and double check this is the real one. Okay? And then you write in the serial number, and then you give away the item, and the deal closed. So simple, right? So simple. Why bill of sale is so important? Why? Let me flip around the case. Let me flip around the example, okay? If you are the buyer and you pay cash, why do you so care about bill of sale? Why? Mariana? Yeah, you want to prove what? You want to prove the purchase, Mariana?
Well, it's all about avoiding the losses.
Yeah, of course. Say, you just pick out the item, and on the way home, and you are stopped by the cop. And the cop searched your car and found out the item was stolen item. How about that? Right? So you want to prove, doesn't matter the item was stolen or not, you are innocent. You are the good faith buyer. Doesn't matter the item is really stolen or not, even though it was a stolen item, but as long as you can prove you are the good faith, then you're off the hook. You're off the hook. So everybody, okay, you took my class, I give you this warning, okay. Doesn't matter how small item it is, could be, okay, how small it is, could be like a $10 item, and you purchase from anybody else, and you get bill of sale. You get bill of sale. That's very, very important to protect your right, because you never know where the item really come from. You never know. All right. So sometimes people say it's a receipt. People say bill of sale. You know it's the same item, it's the same thing, same piece of paper to protect you as the buyer. All right. So this is important because the item is a personal item. You use bill of sale. If the item